Hello and welcome to Free Speech Unmuted, Hoover Institution's podcast on free speech. Your hosts are Jane Bambauer from the University of Florida, and I'm now at the Hoover Institution at Stanford. Before we get to our First Amendment discussion, I wanted to mention that the Stanford Emerging Technology Review for 2025, co-chaired by, among other things, among other people, Hoover Director Condi Rice, has now been released. It's a very interesting document discussing recent developments, not on law, but on technology. I'm looking at the table of contents now. It covers AI, covers biotech, cryptography, lasers, material science, neuroscience, robotics, semiconductors, space, and sustainable energy technologies. So if you're at all interested in any of these subjects, check it out. It's at setr.stanford.edu, and we have a link in the show notes. And we have a guest, Floyd Abrams, who is a legendary First Amendment lawyer. I don't mean that legendary in the sense of semi-mythical. He's quite real, but legendary nonetheless. He has argued 13 cases before the Supreme Court, mostly First Amendment cases. We're delighted to have him here.
Great. So, and one reason for the visit is that Floyd Abrams has just published a piece in the Journal of Free Speech Law, along with his co-author Sandra Barron, Lee Levine, Jacob Schreiner-Briggs, and Isaac May. And we'll have a link to this piece in the show notes, but it's called The Press Clause, the Forgotten First Amendment. And so, Floyd, I hope we could get started by having you explain why you think that the press clause in the First Amendment needs to be revitalized and be understood as something that provides protection beyond what the free speech clause already does.
Well, one of the reasons is historical. That's what the framers thought. When Madison introduced the first draft, as it were, of the Bill of Rights in the first Congress meeting in New York in 1798, he did so with a statement expressing generally why we were going to have the equivalent of a First Amendment. And after talking about the speech, he then said, I'm quoting now, that we would be protecting, quote, the freedom of the press, one of the great bulwarks of liberty shall be inviolable. That word inviolable appears in state constitutions of the time, and in just about all the states, if not all, there is separate reference to the press. Not because the press is more important than, but because it's sometimes somewhat different than freedom of speech. The framers knew and were concerned about suppression of newspapers as well as other sorts of speech, but they talked about newspapers. One of Jefferson's best known observations almost sounds like a line in a show is, and a word left to me to decide whether we would have newspapers, whether we would have government without newspapers or newspapers without government. I would unhesitatingly choose the second. And that's because newspapers mattered a lot in those pre-revolutionary and then post-revolutionary days, and that there had been a history of suppression of one sort or another of the newspapers that existed then. So it found its way after editing into the First Amendment, and we haven't heard much about the press clause to which you adverted earlier, which is, the First Amendment protects for deprivations of freedom of speech, quote, or of the press, unquote. So why did we write the article? We wrote the article because it has become commonplace for lawyers appearing in front of judges representing newspapers and other forms of written speech and the like, to be confronted with, why are you so special? I mean, why do you need a special protection and the like? And when the lawyer would say, there's a big fire in Midtown and the police won't let us in, or there are riots going on, we want to cover it. That's what we do, is to cover newsworthy events. And so we think we should be allowed in. That, at least very often, the general reaction of judges, not always, but very often, is, why am I doing this for those guys? And they even mess up and write stories that aren't quite right, or maybe right at all. And so we wind up with a situation with a constitution with a First Amendment, no less, with specific language about the press, freedom of the press. We can argue about what that means in different circumstances, but specific reference to protecting the press. And there hasn't been a whole lot of constitutional protection of the press, certainly not that sometimes even mentions the reference to the press in the First Amendment. A final introductory remark: the press has won a lot of cases in the court. I've fortunately been involved in a few of them. I mean, it is not as if the press never wins a case, but there is a remaining sense that, in all fairness, there shouldn't be anything special, different, more for the press. Justice Kennedy, a real First Amendment guy, wrote in an otherwise very controversial opinion that the notion that a press corporation receives more rights than another sort of corporation, a speech, let's say, oriented corporation, is completely. He laughed at it in the Citizens United case while ruling in favor of the plaintiffs in that case. And here's someone that I'm really not exaggerating. We, in what I loosely call the First Amendment bar, are often quoting Justice Kennedy because he has written very protectively of free speech. And the idea that his conclusion, after all that, and all of his deep belief, not always shared by all members of the court, but by him, that the notion of greater, different, unique press rights, again, a press corporation having more or different protection than speech rights, was unacceptable, unworthy even. So we decided there really hadn't been an awful lot of focus by the Supreme Court on the press clause, and we would do our best to write something about it, but both historically and from an aspirational point of view. And that's what we did.
So let me see if my understanding tracks yours. I think we'd agree that since the founding, over time, the speech clause has been interpreted, or has sort of become stronger and been interpreted, or such that what was true right after the founding, in the era when, like, the Alien Sedition Act passed, would not pass the same level of protection and scrutiny that we have now under the speech clause, right? So I imagine that one reason Justice Kennedy says what he says is that he thinks that rather than raising the institutional press above the rest of us and giving them special rights, everyone who might be identified as a speaker ought to have their boat lifted as well. And so, I mean, even if he wouldn't say quite put it this way, let me challenge it. Like, why wouldn't we want anything that seems appropriate to give the press? Why wouldn't we want to give those same rights to anybody who is, a bona fide speaker of some sort?
Because there's no room and because they would interfere with what was going on. I mean, to take my two easy examples, a riot, you can't let everybody in. They'll wind up being caught up in a riot. So for a journalist to cover it is performing a special sort of public service that an open door to anybody coming there would not do. And the same, what did I say? Fire, I mean, because I had a case once representing a journalist who was not given a press card for one irrelevant reason, and therefore couldn't cover something that the 2 million then readers of the New York Daily News would have no other intimate access to. So it's not all a situation where you need more or even different than for the press, but sometimes, and the press clause could be, I thought, should be available to that.
Okay, one more question. Oh, sorry, and then I'll.
No,
I'll
Jane,
pass
it's for you.
Okay, well, so I think people will wonder then, well, how do you define who gets to be counted as the press?
And it's not easy, and it certainly is not a one-line answer sort of situation. How it has been defined in terms of press passes by, are you working for a regular entity, which has its dangers too, the regular entities, pre-existing newspapers, at least in the old days when we had newspapers around and about. The fact is there are lots of situations in which a rational society simply cannot let everybody in to watch something that's going on. There's a
like a White House press briefing, for example, to take a very topical example.
Yes. And when an entity makes decisions like a president about not allowing someone in because he or she is offended at what they write or what they carry, that's a good example of where a press clause would be particularly relevant.
Well, so Floyd, let me ask you this. The press could mean two different things in the First Amendment. One thing is the press as industry, like you talk about members of the press, people who are employed by newspapers or broadcasters or maybe websites that satisfy whatever criteria we use to define that industry. The other possible interpretation of the press is it's a technology. It's the printing press. That's how the technology the framers understood there and knew that it was a technological advance that made free speech much more effective in many ways because you could communicate to a much broader public. And of course, because of technological changes, it would also include its technological errors like the internet. So the court has at times said, here I'm quoting from Lovell v. Griffin, a 1938 case. It said that freedom of the press is a fundamental personal right, which is, quote, not confined to newspapers and periodicals. It necessarily embraces pamphlets and leaflets. The press in its historic connotation comprehends every sort of publication which affords a vehicle of information and opinion. So that's focusing on whether somebody's trying to use mass communication technology, regardless of whether they are professional journalists. Leafleters and pamphleteers historically had not been professional journalists, and the people involved, in particular in Lovell v. Griffin, were not. And people involved in many cases who claim free press protections from libel law, let's say, or First Amendment protections more broadly from libel law, are not professional journalists. They could be academics, they could be political activists, they could be just ordinary citizens. So why wouldn't the Free Press Clause be understood as consonantly with what the Supreme Court said in Lovell v. Griffin and has reaffirmed since then, which is that the Free Press Clause in the Constitution protects everybody who uses mass communication technology the same way. Now, there might be some extra statutory protections or extra just regulatory schemes that give extra rights to access, for example, crime scenes that may be defined by not just are you a member of the press, but also how large your audience is or whatever else. Nobody has a right to go to a White House press conference as such. But in the sense that nobody has a right to have the White House hold press conferences, but it sets it up and it may allow for press passes and not give them to everybody, setting aside the question of whether they can restrict them based on viewpoint. So there would be these additional things that could be given to particular kinds of industrial organizations, as it were. But that the Free Press Clause itself covers the lonely pamphleteer and leafleter, who's not doing it as part of the press's industry as much as it covers the New York Times or a broadcaster. Why isn't that the right approach?
I don't have a problem with a broader interpretation of the press that is protected. I have to say my concern is that too often nobody is getting those protections. And that it's essential that at least the press is used in non-technologically advanced times. The press was at least comprised of people who wrote things down, whether or not they were necessarily employed by newspapers and the like. So it doesn't pain me to have a more expansive view of the Press Clause, except that it could too easily make it unmanageable, which is to say, too many people could make too many claims. You know, I want to be at the riot. I'm a citizen. I have a right to be there. I mean, that's not an offensive to me at all, or even unpersuasive position. My view is that at the least, the press, people who gather information for broader dissemination to the public, should be able to play that role. And the Press Clause at least ought to protect them in doing so.
So using the riot example, so it's possible that that the free speech clause alone wouldn't support an argument that an otherwise, time, place, or manner restriction on access to the scene of a riot would, so it wouldn't allow the press in. Why can't we still fix that problem using the speech clause? Okay, I guess the nature of my concern is this who gets to count as press question. So whether we go with the model of, exercising the press clause in order to solve this access problem, news gathering problem, or whether we stick with the speech clause, I guess I would worry less if we had some kind of definition that prioritized access that was, itself quite immune from manipulation by courts or whoever it is that's going to define the press. And so it seems to me, Eugene mentioned, okay, well, maybe if it's based on sort of audience size, that might be viewpoint neutral way of defining something without relying on professional standards, and therefore could be credible. Or another, or you could go wider, like if someone, if someone is claiming a bona fide speech-related reason to access a scene, it seems that even the O'Brien test might allow them to do so, because otherwise enforcing even a time, place, or manner rule would just limit access to speech too much. So I don't know what. So I guess are you nervous about? Are you as nervous as I am about making sure that the definition of a professional press or of a class of people who get special access could itself be manipulated, or even if it's not manipulated, it could be highly distrusted by people who feel like their reporters are being left out? Like the Daily Wire news, listener, how are they going to feel about defining the press in the way that your article does?
First of all, a lot has changed with the change of technology that makes more information available cheaper to more people more quickly. Again, my reaction is that we are moving towards a society in which more information is available, even if there were no press as
Right.
defined in the
As
old-fashioned
defined.
way. Yeah. But in which the press, as we think of it, plays a especially important role. Look, I mean, I spent a good part of my professional life trying to persuade judges that this sounds like 3 generations ago, that television and television journalists were entitled to the same protections as print journalists. And there's no doubt that as there's newer and newer technology, the paper press we see is failing in terms of readership, in terms of power, and the like. They still play an often unique role, if for no other reason, because they are only devoted to getting information out, as opposed to someone sympathetic with an ongoing demonstration, who wants to be there and be part of it and this and that. And, look, we have biased journalists too. All I'm saying is that the inclusion in the First Amendment of a separate reference and authority given to press and power deprived of the government is something we ought to be celebrating rather than narrowing.
Well, so Floyd, I totally agree that it's important to recognize that the First Amendment protects the freedom of the press. And I think the court has recognized it in a lot of cases, because if it only said freedom of speech, that would be open to the argument that, well, when you're talking to someone that's speaking, but when you're using the printing press, that's both literally not speaking, but also much more dangerous, right? If you're speaking and you're saying bad things, you might persuade a few people to do bad things, maybe a couple of hundred in your audience. But if you're actually able to persuade thousands or millions through the use of mass communication technology, that's too dangerous. And in fact, the framers were familiar with a situation where the law, I mean, this was common throughout the world and had been the case in England until several decades before the revolution, where the law basically specially targeted the press as a mass communication technology because it was so dangerous. So the court has said essentially that freedom of the press protects mass communication. Actually, I shouldn't say the court has said this. It's been hazy on exactly where the line is drawn. But one way to understand the court's cases is that freedom of speech or of the press makes clear that both oral speech, as well as some symbolic expression, and speech through mass communication technology is indeed the both of them are indeed protected. So let me ask you in particular how this would play out. A very common example. I think you're right. Sometimes we have situations where you're looking for a press pass to access something, and usually I think that's a matter not of a First Amendment right of access. Maybe it should be, you say, but usually it's a matter of statutory right of access in accordance with, say, police department practices. But let's look at libel law. So let's say we say something on this podcast about a person. We usually don't. We usually talk about ideas more than people. Let's say we say something about a person, and that person says we're libeling him. And some courts had said, oh, well, the press gets special protection from libel law, and but ordinary speakers don't get that kind of First Amendment protection, the protections of the actual malice test and the like. So I say some courts have said it. The great bulk of courts have said no, have said that people have the same right under the First Amendment, whether they're professional members of the institutional press or not, to speak. But let's say that we're sued for libel. Under your view, are we members of the press? We are using mass communication technology on a relatively regular basis to inform people. But, we're not employees of newspapers. We're academics. How would your analysis play out with this? I mean, under the proposal that I'm describing, which I think is in fact actually the dominant view, you don't have to answer the question of whether we are members of the press because we're just using mass communication technology. That means we're protected by the First Amendment fully, as much as the New York Times is. But under your view, it sounds like we may need to decide whether we're members of the press. What would you say to that?
All I'd say is that for the most part, the fact that the press has received certain protections well beyond that in England, Canada, etc., other democratic countries, serves the interest of everyone. And speaking now as a practicing lawyer, some of these cases came out well because it was the press. And one didn't have to sort of explain or try to persuade judges, why it's such a good thing to have this sort of check on government that the press often, but not always, but often provides. So I don't think that providing more clout to the press clause would be a matter of limiting already existing rights. Yes, New York Times versus Sullivan winds up serving the free press, free speech interest of us all, and in a way that it very well may not have, had it not been a press entity involved in that case. So, sometimes I think the fact that it's the press is just a good thing in general for the public in terms of helping to establish more protective law relating to, call it, freedom of expression. But look, I don't think it's an either or situation. Putting some more meaning, using the press clause more, does not have to mean limiting the rights of others, and would probably result in, if anything, some expansion.
Well,
So let me,
let me probe, if I might, a little bit more. So it sounds like you're saying that when it comes to the rights as to which there isn't a physical scarcity, like right to First Amendment protection in libel cases or intentional infliction of emotional distress cases, or maybe even a privilege of news gatherers to refuse to disclose their confidential sources, something that lower courts have recognized not just as to reporters, but also as to academics, as to advocacy group members and such, that as to those, perhaps the freedom of the press or the freedom of the press plus freedom of speech covers everybody at least who wants to communicate to the public. But in situations where you need to pick and choose, because there's only so many, there's only so much room at a press conference, let's say, then you can, then the First Amendment would give a right to newspapers and broadcasters and such, but not to just to would-be leafleters and such. But
There's a natural scarcity,
right,
an unavoidable scarcity.
But here's my question. In that kind of situation, especially like at a press conference, I don't think the First Amendment would secure a right to journalists generally, because there probably are more reporters, more journalists than could fit in many a press conference room. Likewise, when it comes to press conferences in the Oval Office and Air Force One, apparently there are only 13 seats. So it sounds like the Free Press Clause wouldn't give anyone a constitutional entitlement to access to that. Maybe there'd be a right not to be discriminated based on viewpoint, but that's true. But that's true for ordinary free speech as well as free press. So maybe the answer is for the press conferences, and maybe even for crime scenes, there is no constitutional right of access. But as a practical matter, for good political reasons and good policy reasons, there will be some statute or there will be some executive branch rule that says we're going to allow people to access. And then you have to pick and choose in any case, preferably on a viewpoint neutral basis, among reporters, something you can do because it's not a constitutional right of access. And you might favor people based on size of their audience or what have you. But it sounds like at least under my model, you wouldn't have to say the Constitution gives special protection to a particular industry, even in a few situations. Under the model that I'm suggesting, which I think the Supreme Court has endorsed, the Constitution gives equal rights to everyone who is using mass communication technology to speak. And then, of course, the legislature or the executive branch can give extra access in some situations, again, perhaps on a viewpoint neutral basis. What would you say to that kind of explanation of how these various rules do and should play out?
I think that it's harder even by my lights than even your example. Harder to have definitions which will answer all these questions easily, and in practice, it'll never be exactly the same. If I may give a personal example, in the Pentagon Papers case that I was involved in my view, it is only because it was the New York Times that was publishing top secret documents about how we got into the war in Vietnam that information did not lead to criminal prosecution. I believe if Daniel Ellsberg or anyone else with access to top secret documents released them during a war, he'd be in jail. So as a practical matter, the fact that the press exists because of its own power and perhaps the support, and in that case, at least, the support of such a big part of the American public was extremely relevant and helpful to the ultimate recognition of the ultimate result of the case. Or to put it differently, take back what I said that Ellsberg would have been arrested. I think he would have been convicted had he just gotten up and started reading from these top secret papers. Now, I also happen to think if this were World War II, the New York Times wouldn't have published it, but if it had, they might have lost the case. So there are other factors that are on the ground factors. A popular war, a war of defense, this or that. Those aren't legal, but they have enormous on the ground impact. In my view, the sort of expansion or recognition, at least, of more in the way of press rights from the First Amendment will on the whole result in a better educated public as well as a freer one.
So yeah, that kind of leads naturally to what I was going to pose to Eugene, which is, I'm glad you mentioned the Brandsburg, reporter's privilege. Let's assume it may be. I know people sort of have varying opinions about whether the reporter's privilege is, as a policy matter, a good idea, and whether it should be incorporated into for First Amendment protected status. But let's, for a minute, for the sake of argument, at least, let's assume that it is a good tool to make sure that reporters can protect their confidential sources. Eugene, I guess if neither courts nor Congress or any legislature chose to protect those confidential witness relationships in that way, would it bother you if the First Amendment weren't there to sort of establish it, or and if you think it's a good idea, or if we assume it is a good idea, on what basis could we give that privilege to some but not others? Because I do think Floyd's right that if everybody has that privilege, then there are no state secret. There are no ways to protect state secrets, right?
Well, so. I think that here we could look to what courts have actually done. So let's just step back a bit and let me highlight one important point that Jane mentioned. The Supreme Court in Brandsburg v. Hayes, the majority, 5-4 majority, seemed to say that there is no First Amendment privilege for reporters to refuse to disclose their sources, that reporters are like most of the rest of us, that when we're ordered to testify about information that we're aware of that's relevant to some criminal or civil case, we have to testify. There are some exceptions provided for generally by statutes or by common law rules for psychotherapists, for lawyers, for clergy, but the reporters don't get them. But there was this concurring opinion that put a spin on the majority opinion that led many lower courts to, despite the majority, say there is a news gatherer's privilege. So then the question that came up, was, who is entitled to it? And the answer was, generally speaking, and I quote, that a person has to have, quote, the intent to disseminate to the public the information obtained through the investigation. That was the test. And whom was it applied to? It was, of course, applied predominantly to reporters, but also covered would-be book authors, people who are not professional members of the press. They're just writing a book. They're hoping at one point to get published. They've got a different day job in the meantime. It's applied to professors doing research for a possible future academic article. Applied to a film student and a professor trying to produce a documentary film. Applied to political candidates. Applied to political advocacy groups. It applied, as the courts were saying, to a wide range of people, including ones who are ordinary citizens who may want to eventually become book authors, so long as they have the intent to disseminate to the public the information obtained through the investigation. And whom wouldn't it apply to? Well, let's say you've got some investigation of some business and you want to subpoena one of the employees or one of the officers so that you can give testimony that incriminates other people. And he says, no, I'm a journalist. I was acting in my capacity of a journalist, as a journalist. Really? You were gathering information from your fellow business people, from your partners with the anticipation of publishing it to the world at large? Doesn't seem terribly likely. You're not entitled to it. Not because you're not a member of the press, but because you weren't acting as a news gatherer. So I do think that is an important distinction. Now, if I might just return, though, to the related question of the Pentagon Papers case that Floyd mentioned. Floyd is, of course, absolutely right that powerful institutions and popular institutions and powerful people are more likely to win when they litigate. That is the fallen world in which we live. But I don't think it tells us that much about what the rules ought to be. I should also say Daniel Ellsberg might very well have been convicted. As I understand it, he was prosecuted, but the case was thrown out because of prosecutorial misconduct. But that's because he, as I understand it, was disclosing things that he had promised as a government employee not to disclose. And the law has long recognized the difference between something that where somebody is breaching his own obligations of confidentiality and a third party that has gotten this information leaked to it. In fact, there was a case, Bartnicki versus Vopper. I won't go into all the details, but there was a leak from someone who gathered information illegally to an intermediary who then passed it along to the broadcaster. And in that case, the Supreme Court said the First Amendment protects the broadcaster and the intermediary equally. So that may not, definitely doesn't
Right,
protect
as long
the
as they don't
original
induce,
illegal
as long as they-
gatherer. Exactly. But if
Yeah.
these people are acting at arm's length from
Yeah.
them, it is protected. So that's why I think that both the Pentagon Papers case and the journalist privilege cases fit very well with the press as technology example. And just one other example, imagine that it wasn't the newspaper that was releasing it. Imagine it was some government, some legislator, and not protected by the speech or debate clause because it wasn't in Congress, or some state legislator. He leaked it to some state legislator. State legislator says, I want to blow the whistle on this. Or some academic, or some advocacy group. Let's say it was some committee to oppose the Vietnam War. I think they ought to have had exactly the same protection as the New York Times, even if Floyd is right that as a practical matter, it certainly helped being a powerful and authoritative institution when you're trying to persuade the court.
Well, also maybe part of the, oh, sorry, go ahead, Floyd.
No, I just wanted to add to that, these, and it's consistent with a part of what Eugene said. We can't look to law alone to solve these problems or even to address them. Times change, values change, assessments of harm and of benefit change through the years, and that just comes with the territory. I mean, people have not remarked on it yet. I don't mean in this discussion, but in general, our last Attorney General established very clear limitations of the Department of Justice with respect to taking steps going to court to try to find out the identity of confidential sources. That, I don't know if the word regulation, but that policy of the Attorney General's office is still there in writing, and all the current new Attorney General has to do is to tear it up or to announce that it is no longer the policy of the United States, that it would not try to find out the identity via the use of the judicial process of confidential sources. That's just part of life. I mean, it's not even all bad, but it does mean that we just have to not to expect too much from law as the resolver of some of these rather difficult issues.
Though, to be fair, as to that, Congress could have made it into law. There was a time when Congress and the presidency were both in Democratic hands, and the time when they're both in Republican hands, and neither side was willing to fully do that. Had it enacted it as law, then in that case it would be less subject to changes in administration. Although, of course, it would be subject to changes in the composition of Congress.
That's true. Isn't it nice we agree on everything?
Exactly. Well, in any event, Jane, anything further?
Well, I'm just wondering if I could.
Well, there's a lot further. We can keep
there's a lot
talking about
further.
this for hours, for days.
But because I'm a natural, I always like to find as much common, capacious common ground as I can. I'm wondering if what happens under speech protection is not so different from what Floyd wants the press clause to provide anyway. So even looking at the Pentagon Papers case, I think we do all agree that one reason the New York Times was more likely to win than a sort of non-institutional press player is in part because the court had to decide in the context, it was deciding whether it made sense to have a prior restraint given the national security interests. And the court was effectively doing kind of a balancing test. I know they don't, balancing tests within the First Amendment are avoided as often as possible, but they do occur. And in that balancing test, you will ask things like, does the speaker have a track record, or are there systems in place that might lead the court to think that an imminent disaster is less likely because of who it is that we're looking at? And so I'm just wondering if there are, sort of pressure valve releases within the speech clause any days that get some of where you want to go, Floyd.
Yes, some of the answer is yes, but so dependent on the circumstances and the players. I've often looked back on the oral argument in the Supreme Court in the Pentagon Papers case, in which Professor Bickel, representing the Times, was asked by Justice Stewart, suppose when we go back to our chambers and we read the Pentagon Papers, we think that it's likely that one young American man then who had the bad fortune to have a high draft number will die as a result of publication. Are you telling me that in that circumstance, because it's a prior restraint, that the First Amendment must carry the day and I should vote, so to speak, to let that person die? And there was sort of intake of breaths in the courtroom. And Bickel, to his great credit, in my view, and I think we would have lost the case if he had argued otherwise, said, no, I'm not saying that. If that's what you find, in effect, you can enter your prior restraint, but it's got to be that. In effect, nothing less. The next day, the American Civil Liberties Union filed a post-argument brief in a case to which they were not even a party, denouncing Bickel's answer and saying that he was selling out the First Amendment by saying that. My view, as I've just said, at the time and thereafter, that it was an essential answer, regardless of the words we had used about prior restraints. We never said it was absolute, but obviously we were arguing that it was as absolute as would at least allow us to win this case.
Oh, very interesting story. Floyd, always a great pleasure to talk to you about this or about any other topic.
Great, it's good to see you all.
Thank you so much for joining us.
Sure.
And look forward to, I was about to say, look forward to seeing the rest of the audience. But we don't really. Look forward.
We don't even hear them.
Right. Look forward to certainly to seeing you, Jane, and look forward to the next Free Speech Unmuted podcast, which should be coming in a few weeks.
This podcast is a production of the Hoover Institution, where we advance ideas that define a free society and improve the human condition. For more information about our work, or to listen to more of our podcasts, or watch our videos, please visit hoover.org.